Anyway, to cut a long story short, they lost the case. It's a very famous case, and the judgment came out in April 2013. And one of the things why Supreme Court rejected the patent on imatinib mesylate was saying that that crystal form of your drug, for which you're claiming patent, it does not significantly differ in terms of efficacy with the previous form, which was not patent. And here they defined efficacy means, I repeat it 100 times, efficacy means therapeutic efficacy. It does not mean that if it has some property like less density or less sticky, etc., etc. I have to show that it is rated to curing me better, therapeutic efficacy. So, imatinib mesylate does not qualify as an invention as per 2.1 clauses J and J. J is a definition of invention, J is definition of inventive step. Beta crystalline form does not satisfy the section 3D criteria, therapeutic efficacy. Improved therapeutic efficacy must be claimed and established. That's what the Supreme Court said. You just can't say that what they did was, what silly thing Novartis did was, they said it's got improved bioavailability and efficacy. How? They took 30 rats and gave this beta crystalline form in the older form and said this has got better availability in this 30 rats. Court said this is not proof that it has got therapeutic efficacy. Sorry, we don't accept this. So, improved bioavailability also leads to better therapeutic efficacy. Now, this bioavailability means when you take a drug, it should be available to the body. Paracetamol, whatever. And certain drugs, as I said, injection takes almost zero time. It straight away enters into the blood. It has got fantastic infinite bioavailability. A tablet takes 15 minutes. A well-formed tablet takes 15 minutes to enter the bloodstream. So, once it enters the bloodstream, then it will go to the site of action of the particular drug, particular problem, and then that's how drugs act. So now that is called bioavailability. Now with drug, this thing is improved bioavailability because of this. So they proved the 30 racks in improved bioavailability. But court said it may be improved bioavailability, but you have to demonstrate it has got improved efficacy. Bioavailability does not necessarily means improved efficacy. And they said efficacy means not any kind of efficacy, it means therapeutic efficacy as far as medicines are concerned. So, this has revived the debate about, so Novartis lost this case. It means it's a big thing nationally and internationally. I cannot stress it enough because a lot of countries are looking for, because Section 3D was overruled and they gave a patent to Novartis. I think India would have this, it has got its name of supplying drugs to the world, etc. All that would have come down. So, but they got a lot of lobbies against all this, Section 3D and all this. One of them is this US-India Business Coalition. Our Section 3D prohibits incremental innovations, small innovations. But they're saying 65% of the drug approvals in the United States is because of incremental innovations. So what? Maybe there in the United States, it's not our law, it's not according to us. So they say you change the Section 3D. This is kind of lobbying. And lobbying means this is not about arm twisting politically. If we don't change, we will not agree to giving you nuclear deal, kill some weapons and that kind of thing. All kind of things, including trying to topple politicians who they will do all kind of things. And so this is the kind of lobbying. And they may even blow up your submarine. Who knows? Submarine, I don't know whether it blew up 3-4 days back. I don't know who blew it up. I don't know why so many people lost lives. So this kind of thing can occur. This is lobbying, international. So this is and why is the US doing this? Because most of the big pharma, 80% of the medicines, modern medicines in the world are consumed in the United States. And therefore a lot of big pharma market, and they want to expand. India is a big market. And India is also a potential threat because we are making medicines all this through process patent, through reverse engineering and so on and so forth. So this is the politics of this thing. So, and they're quoting other things to say that how incremental innovation should be allowed. And this is the substance of all this free trade agreement also. There are a lot of nowadays bilateral free trade agreements. Actually, there should be no need for bilateral free trade agreements because WTO, World Trade Organization, is supposed to solve all these problems because there is one trade law for all countries. But no, they say the United States started this with Mexico, NAFTA, etc. EU is trying to have a free trade agreement, and many of the free trade agreements have clauses which are beyond TRIPS. Means it's called TRIPS plus. And you're not supposed to have laws even beyond TRIPS, but this thing we want, which means dilution of Section 3D, putting some, giving patents for new uses of existing drugs and so on. So these are some they come out with papers like this: value of incremental pharmaceutical innovation, benefits for Indian patients. These are all lobbies, and they are very well-heeled lobbies. Now, one of the things in our Patents Act, which is again a very impressive thing, is the compulsory license. To issue compulsory. Compulsory license means if you give a patent to a company, say a pharma company, and in 3 years, if it has not made the drug in India, it's called working on the patent. If I made it available in sufficient numbers, if I got 1 lakh patients of a particular drug, and I'm making enough only for 10,000 patients,